Good day and welcome to episode 6 of Stratagem LP's Legal Podcast. This is the podcast where we review case laws and discuss topical legal issues, allowing our audience to stay updated on the law while on the go. Whether you are driving at home, working out, or relaxing, we've got you covered with insights that help enhance your legal knowledge. In today's episode, we are diving into an important case involving banking law and international trade law, specifically the application and effect of uniform customs and practice for documentary credits, christened UCP 600. From this inception, I wish to point out that documentary credit is the same as letter of credit in international trade law. The case under review is the Supreme Court case of Owigs and Obigs Nigeria Limited versus Zenith Bank Plc, which touches on some key principles, including but not limited to the autonomy of letter of credit, negligence in international contracts, and the tricky issue of special damages. Let's break it down further. So let's start with the facts. The appellant, Owigs and Obigs Nigeria Limited, entered into a banking relationship with Zenith Bank, hoping to secure export finance facilities for trade contracts backed by letter of credit from foreign entities. They hired a third-party broker, Eglon Group Asia Pte Limited, to help secure contracts for the export of Nigerian solid minerals to China. Everything seemed set up for international business success. However, there is a twist. Zenith Bank failed to confirm the letter of credit provided by the Chinese firms through their bank, ICBC, despite prior negotiations. And this is where the cause of action arose. The contracts were cancelled and the appellant became liable to pay penalties to Eglon Group Asia for the breach caused by Zenith Bank's refusal to confirm the letter of credit. So, the appellant took the matter to court, seeking a range of damages for the losses they incurred. Let's walk through the key legal principles. The core legal principle featured in this case is UCP 600, the set of international rules governing letter of credit. This law guides transactions between buyers, sellers, and banks in international trade. UCP 600 aims to standardize practices and reduce misunderstandings. The question here was whether Zenith Bank violated these rules by failing to confirm the letter of credit. The origin, nature, and effect of UCP 600. UCP 600 was developed by International Chamber of Commerce (ICC) to standardize rules for documentary credits, thereby reducing confusion and disputes in international trade. These rules ensure uniformity in trade practices across borders. In the case at hand, UCP 600 governed the contract between the appellant and respondent, and it became a crucial point of contention in the legal proceedings. The application of UCP 600 in Nigeria. UCP 600 came into effect in Nigeria on July 1, 2007, following a directive from the Central Bank of Nigeria, CBN. The directive required all letter of credit issued from that date to comply with UCP 600. The appellant argued that the Court of Appeal misinterpreted UCP 600 in its judgment, though they failed to demonstrate specific provisions that have been violated. The meaning and purpose of a letter of credit. A letter of credit is a financial instrument used to facilitate international trade transactions. It is a promise made by a bank to pay the seller upon the presentation of documents that meet the terms specified in the letter of credit. The letter of credit protects the buyer by ensuring that payment will only be made once the seller fulfills the conditions of the contract. Types of contracts involved in letter of credit transactions. There are 4 primary contracts in a letter of credit transaction. 1. Sales contract between the buyer and the seller. 2. Contract between buyer and issuing bank for issuance of the letter of credit. 3. Contract between issuing bank and confirming bank for the confirmation and verification of payment. 4. Contract between confirming bank and seller for making payments based on document verification. Banks in these transactions are not concerned with the actual goods being traded. They only handle the documents that prove the terms of the letter of credit. Independence of letter of credit from sales contracts. One of the most important principles under UCP 600 is the autonomy of letter of credit. According to Article 4A and B of UCP 600, the letter of credit is independent of the underlying sales contract. This means that even if the sales contract is breached or becomes void, the bank is still obligated to honor the letter of credit as long as the documents provided meet the terms of the credit. Autonomy and strict compliance. While the letter of credit is independent of the sales contract, it is subject to strict compliance. This means the bank must adhere to the precise conditions stated in the letter of credit and will not honor it if there are discrepancies in the documents. In the case we are examining, the respondent's failure to confirm the letter of credit violated the principle of strict compliance, which contributed to the cancellation of the appellant's contracts. Negligence and its impact on international trade. The Court of Appeal ruled that the respondent's failure to confirm the letter of credit constituted negligence. Negligence in this context refers to the failure to exercise reasonable care and fulfill obligations under the contract. This decision emphasizes the critical role that banks play in confirming letter of credit and how their failure to do so can devastate trade relationships and businesses. In this case, the Court of Appeal found Zenith Bank negligent, ruling that the failure to confirm the letter of credit directly led to the cancellation of the contracts and the appellant's losses. This was a big win for the appellant on the negligence front, but the appellant was dissatisfied with the quantum of damages awarded by the Court of Appeal. Hence, the appeal to the Supreme Court. The doctrine of privity of contract is another major principle we saw in this case. Under this doctrine, only the parties to a contract can enforce or terminate it. So, Zenith Bank argued that it couldn't be held liable for breach of the underlying contract since it wasn't a party to those agreements. While the court upheld this principle, it also looked at how Zenith Bank's actions impacted the appellant's business relationships. Moving on to damages. The appellant sought both special damages and general damages. Special damages must be proved with strict evidence. The appellant tried to claim lost profits based on projections, but the court found these figures to be speculative and not backed by solid proof. This was a significant hurdle in the appellant's case. On the other hand, general damages, which are awarded for intangible losses such as the loss of business or goodwill, were seen differently. Here, Justice Ogunwumiju, in his dissenting judgment, opined that the appellant should be compensated for the harm caused to their business reputation, even if they couldn't strictly prove the financial losses. This opinion highlighted a deeper view of how banks should be held accountable for sabotaging the terms of international contracts. Let's also touch on negligence. In legal terms, negligence is the failure to take reasonable care in a situation where harm could result. The Court of Appeal found that Zenith Bank's failure to confirm the letter of credit was indeed negligent, which directly led to the cancellation of contracts and the appellant's financial losses. A critical point in this case is the burden of proof. The appellant had to prove that the damages it claimed were actual losses. Regarding special damages, the burden of proof is on the claimant to show specific, real evidence of loss. Unfortunately, the appellant failed to meet that burden, especially with the speculative loss of profits. Now, let's get into the dissenting opinion from Justice Ogunwumeju. The law lord held that the appellant should receive general damages for the loss of goodwill and the breakdown of their international relationships, which were directly caused by Zenith Bank's negligence. In his view, the bank had a duty to honor the terms of the confirmed letter of credit and should be held accountable for the harm it caused to the appellant's business. The dissenting opinion in the Owigs and Obigs Limited versus Zenith Bank Plc case is a critical analysis of the broader implications of banking negligence in international trade. While the majority judgment upheld the autonomy of letter of credit under UCP 600, the dissenting judge recognized the far-reaching consequences of Zenith Bank's failure to confirm the letter of credit facilities. This failure disrupted international trade, damaged the appellant's business reputation, and caused significant financial losses. The dissenting opinion serves as an important reminder of the need for accountability in banking relationships, particularly when such relationships have a direct impact on international commerce. It also highlights the importance of maintaining trust and reliability in global trade, where the failure of a single financial institution can have consequences far beyond the immediate parties involved. Ultimately, the dissenting opinion calls for a more nuanced understanding of the responsibilities that banks have in facilitating international business, urging that they be held accountable when their negligence disrupts such important transactions. He held that the appellant was entitled to 500 million naira damages. So what's the takeaway from this case? 1. Autonomy in letters of credit is key. Once the proper documents are presented, banks have an independent responsibility to honor letter of credit. The underlying contracts between buyers and sellers do not affect this duty. 2. Negligence can lead to serious legal consequences, especially when it results in contract failures and business losses. 3. Proof of special damages is critical. Special damages require strict proof, while general damages for intangible losses like harm to business reputation may be easier to prove. 4. Even though a bank may not be privy to the contracts between the buyer and seller, it still has an important role in ensuring those contracts are executed properly, especially when it's the confirming bank in a letter of credit transaction. And there you have it, folks, the Owigs and Obigs Limited versus Zenith Bank Plc case, a significant ruling in the realm of international trade and banking law. It reminds us that while legal principles like autonomy and privity of contract are fundamental, the real-world consequences of negligent actions in international finance can't be overlooked. Thank you for listening to this episode of Stratagem LP's Legal Podcast. I remain your principal host, E.B. Ochuma Esquire. My special thanks to my review assistant, Ms. Oyindamola Daramola. Join us next time as we continue to explore the legal issues that shape our society. Until then, stay informed, stay empowered, and keep learning. Thanks.